Let's get some more now in our top story. The dramatic announcement of a civilian trial for 5 suspected plotters of the 9/11 terror attacks, including the confessed mastermind, Khalid Sheikh Mohammed. Our senior legal analyst, Jeffrey Toobin, is joining us from New York. Explain why a civilian court for these 5 as opposed to a military tribunal.
Well, why the Justice Department made this choice is that, well, the American legal system is widely respected around the world as a fair venue for the resolution of criminal cases. The decision was made that if we want a judgment for the execution of Khalid Sheikh Mohammed and his associates to have credibility around the world in the way that Guantanamo Bay never did, we have to give them the full protections of the American Constitution, and only then will the verdict be seen as fair and be fair around the world. So
this was basically in part designed to reassure the rest of the world?
I think that had a big part. Guantanamo Bay was a huge issue, a huge black mark in terms of American international relations. And it is a classic difference between the Bush administration and the Obama administration. And this decision, as we learned today from the prior 2 attorney generals, is one that the prior administration would not have made. This one did, and we'll see whether they made the right choice.
Because other detainees, including those who were associated with the attack on the USS Cole, will be tried by the Obama administration before military tribunals. And the explanation they're giving that one operation was done overseas as opposed to one being done in New York City and the Pentagon and Pennsylvania, to a lot of folks, that doesn't really seem to make a whole lot of sense.
It doesn't make a lot of sense to me either. I think a lot of it has to do simply with the available evidence in each case. Remember, the bombings of our embassies in Kenya and Tanzania, which of course took place overseas, those were tried in American courtrooms, not in military tribunals. So the distinctions the Obama administration is drawing here, let's just say they are new. They may be right or wrong, but they're not ones that have traditionally been drawn.
Listen to this exchange the Attorney General Eric Holder had at his news conference earlier today.
Are you confident that they will actually be able to stand trial, that they'll be found mentally competent, and that their harsh interrogation techniques like waterboarding, that they'll still be able to go to trial despite that?
I would not have authorized the bringing of these prosecutions unless I thought that in the outcome, we would ultimately be successful. I will say that I have access to information that has not been publicly released that gives me great confidence that we will be successful in the prosecution of these cases in federal court.
Wow. What is he referring to? Access to information that hasn't yet been made public?
Well, that certainly piqued my interest as well, Wolf. The context of that statement suggests this. Obviously, one of the big problems with this case is going to be the waterboarding. No American courtroom is going to admit testimony, admit statements that someone made while they were being waterboarded. What Holder's statement suggests is that there is other evidence of statements made by Khalid Sheikh Mohammed and the other defendant who was waterboarded. There's other evidence not tainted by the torture that will prove their guilt. But remember, the defense here is going to argue that the waterboarding alone is so egregious that that's going to justify the dismissal of the case. I don't think that motion will win, but those are the kind of legal issues we're going to see sorted out over these many, many months it will take to get this case to trial.
Do Khalid Sheikh Mohammed and these 4 others, for all practical purposes, in this federal courtroom, have all the rights of U.S. citizens?
Absolutely. You're either an American defendant in an American courtroom or you're not. If you are a defendant, there are no restrictions on your rights, and that means including access to the evidence. And that's what's so important here, because a defendant has the right to prior statements that he made. He may have the right, for example, to the videotapes of his waterboarding, if they still exist. He could broadcast them. He could use them in the courtroom. That could have tremendous propaganda advantage. He could have access to very secret intelligence matters, which certainly are part of this investigation. There's something called the Classified Procedures Information Act, CIPA, which limits the public disclosure of classified information, but defendants get access to this sort of information. That's something that's going to be very difficult to manage and very important in this case.
Because that raises the question about classified secret information. How much access will the defense attorneys have to classified information? Will they be allowed to put it out in public? How damaging could that be to U.S. national security if sources and methods of al-Qaeda, for example, are exposed?
And the stakes could not be higher, because there is nothing our government cares about more at this moment than the intelligence efforts to stop terrorism, wiretapping, bugs, etc. And these are the worst of the worst, as Donald Rumsfeld said. So they will have access to the greatest secrets, potentially. We'll see how the judge manages that. That's why I think in particular some people are worried about whether this case is a bridge too far for our legal system.
Can they get a fair trial in New York City?
Well, you know, think about this question. Jury selection. This courtroom is about a 15-minute walk from Ground Zero. All the jurors will have exposure to 9/11 one way or another. Certainly the defense may ask for a change of venue. Is there another courtroom in America that would be secure enough for this trial? A big issue. But what the government will certainly say here is we will have detailed voir dire of all potential jurors. They'll fill out questionnaires, they'll be questioned under oath, and that will be able to assure a fair trial. Just on the jury issue, I mean, and that's only one issue, but again, that's going to be very tough, and the judge is going to have to take a firm hand, and he or she, in that area, like so many others, will have his or her work cut out for him.
Jeffrey Toobin knows a lot about this stuff. He's a former assistant U.S. attorney himself. Jeffrey, thanks very much.
Okay, well.